Any mention?
Going again. Backs.
Hearing item number 1.
Aye. You want DB? Yes.
May please, Your Lordship. Lordship, on the last occasion, my Lord Senior, on the appellant's behalf, my Lord, has summed up his arguments, my Lord. It is for the state to reply, my Lord. My Lord, for that, my Lord, I'll straightway lead to the evidence, my Lord.
I will. Mr. Mata, you finished your submissions, no?
Yes, yes. My point I have given because the whole judgment is based on the case diary, and I've cited 2 decisions of Supreme Court also to that effect. And apart from that, the IO says that I have not examined any witnesses. How come the PW 1 and 2 came in? So those are the prejudice caused.
My Lord, the paper book, my Lord.
Yes.
I'll straightway, my Lord. Take Lordships to page number 34. That is the examination in chief and cross of PW1, Srimati Wangtinglang Shingo, wife of deceased number 1, victim number 1. Page 34 of the paper book, my Lord. This is the type copy, man. If I may read, my Lord. My Lord, before I start this, reading this, I beg to bring to your Lordship's notice that statement of the prosecution witnesses, my Lord, were recorded after more than 2 decades, my Lord. The occurrence is of 1992, and my Lord, it was recorded on 18th November 2015, my Lord.
Where was the case languishing in? Before the
My
unseparated
Lord, it was
court.
before the separation of the judiciary and the executive, my Lord. It was lying before the executive, my Lord. So thereafter, finally in 2015, it was transferred to, my Lord, fast track court. That is how the matter proceeded, my Lord. Page 34 is the type copy, my Lord. And PW1 is an eyewitness, my Lord.
Yes.
PW1 and PW2 are eyewitnesses. I know the accused Sri so-and-so who is present in the court today. Means she has identified the accused person in the court. On the day of the incident, but I do not remember the date, month or year. My late husband, Sri so-and-so, while returning from the pine groves, the accused person stabbed my late husband with a dao on his head. Lordship will mark the word head, my Lord. It's very significant. I was in my compound. I saw the accused firstly stabbed my husband, thereafter stabbed my mother, Srimati so-and-so, in the neck. Neck and head, my Lord. First, DW1 is injuries on the head and neck, that is D2, my Lord. This is 2. Thereafter, the accused dragged the body of my late husband to his house, and my late mother asked the accused why he killed my husband. The accused then stabbed my mother in the neck at my compound. Both the victim died on the spot, and the accused dragged both the bodies and put them together. Thereafter, the accused fled from the scene, my Lord. Ran away, my Lord. During the day of the incident, 3 of us were present, myself, Srimati Sumjur Sungo and Srimati Aurita Sungo. I do not know who informed the police, but on the same day, the police came in the evening and took the dead bodies. That's all I have to say. In the cross, my Lord, My husband was a daily wage laborer. The accused is the uncle of my late husband. The place of occurrence is about 10-15 meters approximately from my house. At the time of the incident, I was at my veranda and there were 3 other adults were present. They were also standing with me at the veranda. I did not raise any alarm on seeing the incident as I was scared. I'll take a pause here, my lord. Now, when deceased number 1 was being attacked, my lord, and he died, my lord, the mother, that is the deceased number 2, asked from the accused why he killed deceased number 1. And what she got? She herself was killed. Seeing that, my lord, the witness number 1 could not make any. As I was shocked, therefore, I was not able to convey any information to the police. I had not informed about this incident to the co-villagers or even the headman. No one else except 3 of us came and saw the dead bodies lying in my compound. It is not a fact that my late husband had any grudge with the accused during his lifetime. It is a fact that I saw the accused dragging my late husband from the village footpath to my compound. It is a fact that at the time when the accused stabbed my mother, I was standing nearby my deceased mother, and on seeing the incident, I ran to the place where my husband was lying to find out if he is still alive. At that time, Srimati Sumjur Sungo and Srimati Irita Sungo were standing there. Srimati Irita Sungo was standing in the veranda carrying baby, and Srimati Sumjur Sungo was just standing. Srimati Sumjur Sungo is my elder sister, and Srimati Irita Sungo is my niece, aged about 15-16 years at that time. It is a fact that even Srimati Sumjur Sungo and Srimati Irita Sungo did not raise any alarm at that point of time when the incident took place. I remember that my husband was stabbed by the accused on his head and my mother was cut at the backside of the neck. The police arrived at my residence at about 7 p.m. It is a fact that the accused had used the dao to commit the offence. It is not a fact that I have not seen the incident with my own eyes and the story of the incident is fabricated. Now, my lord, by reading this, my lord, I beg to submit that PW1 is a eyewitness, my lord. Now, I cannot, my lord, amplify the evidence as of now. I have to go through other PWS also, so that I'll come to the part of corroboration, my lord. Lordship will come to page number 36. That is the PW2, Sri Haminyang. I know of the case as the murder deceased late so-and-so was my mother and late so-and-so is the husband of my sister Srimati so-and-so Sungo. During the time of the incident, I was also married and myself and my sister so-and-so along with our husband were staying together with our mother in the house. I do not remember the date, month, year of the incident since it had happened decade back. My brother so-and-so died sometimes back. On the day of the incident, around 3 p.m., I was grinding paddy in the compound of the house while my mother was also nearby sitting. The accused Sri Edwin Sungo is from the same clan which she belongs, while the husband of my sister Sri Lo Ravan was somewhere outside near the house. While I was grinding paddy in the compound, the accused came with a dao to our compound and straight away chopped Lo Ravan with a dao, and thereafter accused came and chopped my mother, and then the accused pulled both the dead bodies and kept them together, and then accused left the place. I did not do anything as only me and PW1 are present. After some time, villagers came, police also came to the house and removed the dead bodies to Civil Hospital Joy. I have also signed on the inquest report, Exhibit 1 and Exhibit 2. Exhibit 1 by 1 and Exhibit 2 by 1 is my signature. I have nothing more to say. On cross-examination, on the day of the incident, my husband, so-and-so, was also present in the house and he also saw the incident, but my husband did not raise any alarm and he was scared. There are other houses of the neighbor near our house. Late so and so was doing the job of grazing cattle, but on the day of the incident he did not go for grazing cattle as he was having some work in the house. It is a fact that none of the neighbors saw the incident. The person who saw the incident, only me and PW1, my husband did not see the incident though he was in the house. At the time of the incident, when the accused chopped deceased so-and-so, the deceased was outside the compound of the house. So-and-so was chopped on the head, while my mother was hit on the back of the neck. I'll take a pause here, my lord. Now, PW2 is also an eyewitness, my lord, and has thoroughly corroborated the statement of PW1, my lord. Both of them were present. Both of them has described the nature of injuries and the part of the body that was being attacked. And with what it was attacked, even the, my lord, the weapon of crime was also described, and it corroborates each other, my lord.
Yes.
During the time of the incident, I had 4 children and they were all minor. Now the age of my eldest daughter is 30 years. I do not know why the accused killed my mother and La Ravan. Prior to the incident, accused never visit our house, though we know him being of the same clan. I have my thumb impression, exhibit 1 by 1 and exhibit 2 by 1. So, my lord, PW1 and PW2 are not only eyewitnesses, my lord, they are also the, my lord, witnesses in the inquest report prepared, my lord. That is exhibit 1 and 2 on the dead body of deceased number 1 and deceased number 2. PW3 at page 33, my lord. He is the inspector, not very important, my lord. I retired from service as Inspector of Police in 1998 after having served in the police force for 32 years. In 1992, I was posted in Joy Jaintia Hills district as Officer in Charge Joy PS. On 15 May 1992, Mr. Wanbai Sulet, the then MDC of Sangpung constituency, along with others, came to the PS and produced one admin sungo and reported that the accused have been committed a double murder on the night of 14/5/1992 at so-and-so Saipung. On this information, I made GD entry by Joy PS case number GD numbers 500 dated 15/5/1992. The accused was kept at the lock-up and I entrusted the investigation to the in charge of Reliang Outpost SIGS Wallach, who is since deceased. Now, my lord, I'll take a pause here, my lord. First thing, my lord, the one question arises here, my lord. There is no formal FIR. Now the question is whether GD entry can be treated as FIR, my lord. I'll come to that in the later stage, my lord. Second is, my lord, whether the in charge will corroborate that he had been endorsed with the investigation, my lords. And, my lord, here, whatever he has stated, my lord, has become a part of evidence because cross was being declined. Now, I'll come to page 39, that is PW4. There are only 6 witnesses, my lord. Q. Pala. I joined service on 1st May 1979 as ASI and retired in December 2015 as sub-inspector. I was posted in 1994 till 1995 as officer in charge. The instant case was investigated by Sri G.S. Walong, who has since expired. The date of the occurrence was in the year May 1992. After the investigation is completed by late SIGS Walong, the charge sheet was submitted and I have forwarded it to the court as the then officer in charge. As per investigation of late SIGS Walong, the facts of the case is that on 14/5/1992, during the night time, 2 persons, namely Srimati so-and-so and Sri so-and-so, were murdered by the accused person so-and-so in their house at so-and-so Mosai by means of a dao and left the dead bodies there. The IO held the inquest and dispatched the bodies to Joy Civil Hospital for post-mortem. IO has also examined 3 witnesses on the completion of the charge sheet submitted. The charge sheet under section 302 IPC against the accused person. I have simply forwarded the charge sheet in this case. So cross was being crossed. From the record, it is seen that there is no seizure was made. So in this case, my lord, the weapon of crime, my lords, was not seized. Now whether
Yes.
conviction can be held in absence of, my lord, recovery of the weapon. That point arises here. PW5, Dr. M. Pade. Now, my lord, here he is deposing on behalf of late Dr. G. Pasa. G. Pasa had conducted post-mortem on the, my lord, 2 dead bodies, and he died, my lord. So subsequently, my lord, when this had to be exhibited in the court, my lord, so Dr. M. Pade had come forward and deposed. I joined service in 1980 and retired as Joint Director, Health Service, Government of Meghalaya in the year 2013. Since I joined service in the year 1980, I was posted in Joy Civil Hospital in the year 1983 till 2010. During this period of my posting at Joy Civil Hospital, late Dr. G. Pasa was also posted at Joy Civil Hospital, and we served together till he retired in the year 2007 and has since expired. On 16 May 1992, Dr. G. Pasa had conducted a post-mortem on 2 dead bodies. Number 1, this is very important, my lord, because I am going to describe the nature of injuries, my lord. Number 1, dead body of late Ravan, Low Ravan, aged 60 years, at 11 a.m. The dead body was identified Hami Sungo, brother-in-law of the deceased, and Robi Ravan, brother of the deceased, finding fresh dead body of average build, height and size. Injuries, my lord, 6 cut wounds. My lord will note 6, not 1, my lord. So it is not about sudden provocation or no intention, my lord. 6 cut wounds on the head, that is the skull, all in the back of the head, occipital region, size 6 to 7 inches, my lord. Means, my lord, more than half feet. And deep to the bone. Number 2, multiple fracture of the occipital bone, torn at the side of the injury, brain matter seen coming out of the fractured end of the bones, no other injuries detected. In the opinion of late Dr. G. Pasa, the cause of death was due to shock and hemorrhage resulting from the above mentioned injuries. Weapon used, heavy and sharp object. So, my lord, PW1 and PW had clearly stated the weapon used was a dao. So, here also the finding is, my lord, precisely, my lord, points to that. Number 2, the dead body of, that is the disease number 2. The dead body of late Lakma Sungo, 70 years of age, female, Panar identified by Hami Sungo, brother of the deceased. The postmortem of late L. Sungo was conducted at 11:30 a.m. Finding fresh dead body of average build, height and size. Injuries, cut wound in the head, scalp, on the right parietal region. The wound is 6 inches long and goes deep through the bone. Number 2, cut wound in the base of the neck. My lord, the injuries described by PW1 and PW2 was back of the neck. So, my lord, here goes. Cut wound in the base of the neck, on the back side, size 6 inches long and piercing the bone. Number 3, fracture of right parietal bone detected. Membrane of the brain torn at the side of the injury. Brain came out from the fractured side and spinal cord is cut through at its upper part. No other injuries detected. In the opinion of late Dr. G. Pasa, the cause of death was due to shock and hemorrhage resulting from the above mentioned injuries. Exhibit 4 is the postmortem report of late Low Ravan, and Exhibit 5 is the postmortem report of late Lakma Sungo, and 4/1, 5/1 are the signatures of late Dr. G. Pasa, which I know. So, my lord, here the cross is declined. Now, the last witness, my lord, at page 42, PW6. I joined service in 1992 as Sub-Inspector of Police and posted at Joy erstwhile Jaintia Hills district till the year 1992. I am the IO of the case endorsed. Now, my lord, in the evidence of my lord PW4, who had submitted the charge sheet, had stated that PW6 had died, but in fact he was retired. So therefore, that is a my lord misunderstanding. I am the IO of the case endorsed to me by then OC Joy PS Inspector K. Khongla. So PW3 has stated in his chief my lord that I had endorsed the investigation to On being endorsed with the investigation, I proceeded on 16/5/1992 at night time to the place of occurrence, which is at Saipung, in the compound of murdered deceased Lakma Sungo. There are two dead bodies, one of late Srimati L. Sungo and L. Sri Los Raban in the compound. I have held inquest on both the dead bodies, which are identified by the family members of the deceased. The dead bodies were lying on the ground covered with a shawl. Exhibit 1 and Exhibit 2 are the inquest report prepared by me, and Exhibit 1 by 1 and 2 by 2 are my signatures. The dead bodies were sent for post-mortem to Civil Hospital Joy, and I returned back to the PS, and next day I was transferred to headquarters at Shillong. I have not examined any witness in this case. This was what Learned Senior was pointing to, my lord. Cross-examination. The date of the occurrence was 14/5/1992, and the incident took place at the place of occurrence. When I proceeded to the place of occurrence on 16/5/1992, the dead bodies were still lying in the compound. The dead bodies were sent for post-mortem on 16/5/1992 night only. I have noticed cut injuries on both the heads of the deceased. It is a fact that I have not reflected the cut injuries in the inquest report prepared by me in respect of late Lakma Sungo. So that is that, my lord. Now last I'll be reading, Lordship will peruse that accused person was being examined under section 313, confronting him with all the evidences collected against him, my lord. Now kindly see the nature of, he was put with 9 questions, my lord, and he has not explained anything, my lord. 7 except simple yes or no, my lord. Why I am saying this, my lord? Because non-explanation under section 313 amounts to a missing link in the chain of evidence, my lord. Now firstly, before I take my lordship, before my lord, I analyze the evidence part, then the law part, my lord. My lord, this is a case of where there are 2 eyewitnesses. So this is not a case of circumstantial evidence. Why I am saying this, my lord? The word motive becomes significant, it becomes important in case of circumstantial evidence, my lord. Not when there is a presence of ocular and my lord, ocular and eyewitnesses, my lord. So, my lord, I have prepared brief. It will be very easy for your lordships to, my lord, I will be reading this. Now, I'll be analyzing the, my lord, evidence. Then I'll take your lordship to the legal part, legal aspect. Lordship, for the sake of convenience, my lord, I have given the full form of the abbreviations. So, my lord, PW1, what she has stated in the examination in chief, in brief, page 1, my lord. She deposed that on the day of the incident, deceased number 1, Lokan Ravan, was stabbed by the accused with a dao on the head when he was returning from the pine grove. She further stated that at that time she was in the compound veranda, place of occurrence, which is about 10-15 meters from the house, and she saw that first the accused stabbed deceased number 1, And when her mother, deceased number 2, asked the accused why he killed D1, deceased number 1, the accused then stabbed deceased number 2 on the neck. Both the victims died on the spot, and accused dragged the bodies and put them together in a heap and thereafter fled from the scene. She further stated that Srimati So-and-so, PW2, and Miss Ayorita Sungo, 15-16 years old, were also present at the place of occurrence. She also identified the accused in the courtroom. In the cross-examination, she stated that she did not raise alarm as she was scared. The incident happened at 4 p.m. She was in a state of shock. Now, Lordship will see the corroboration part. The same follow. Number 1, PW1 description of the nature and areas of the injuries are corroborated by the deposition of PW5 Dr. M. Pade, who deposed on behalf of late Dr. G. Pasa, who conducted the post-mortem on the two dead bodies. So, my lord, the statement of Dr. Pade, my lord, that is PW5, the nature of injuries, my lord, and the opinion of the nature of the weapon used, my lord, those corroborates the statement of the PW1, my lord. Number 2, PW1's presence at the place of occurrence and witnessing the occurrence corroborated by PW2. PW2 is also another eyewitness. In her examination in chief, she has clearly stated that PW1 was also there.
Standing there.
My lord, yes.
Yes, with the baby.
Yes. PW3, now point number 3, my lord, corroboration number 3. PW1 statement stand corroborated by the inquest report bearing the signature of PW1 as witness, my lord. So in the inquest report also, when the IU, that is the PW6, my lords, when he was examined, he had stated that he had prepared the inquest report. PW2 has stated that I had put my signature as one of the witnesses, my lord. So therefore, this statement also stands corroborated. Now, that apart, my lord, PW1 was examined on 18/11/2015 after 23 years of the date of occurrence. PW1 is a rustic and illiterate housewife, and when examined after more than 2 decades, my lord, is only natural and human to make some contradictions, minor contradictions, my lord. If it is only case of, my lord, a tutored witness who will say the same thing like a tape recorder after 100 years also, my lord, a tutored and interested witness. But a natural eyewitness is bound to make some minor contradictions, my lord. That is my respectful submissions, my lord. Now, to analyze the evidence of PW2, in the examination in chief, she deposed that on the date of the incident at 3 p.m., she was grinding paddy in the compound of the house place of occurrence, while her mother, deceased 2, was sitting nearby. When the accused came with a dao to the compound and straightway chopped deceased number 1, and thereafter the accused came and chopped deceased number 2, and the accused pulled both the dead bodies and kept them together, and the accused left the place. She stated that PW1 was also present. After some time, the villagers and the police came and removed the dead bodies to civil hospital Joyce. She signed the inquest report, Exhibit 1 and 2. In cross-examination, she stated that her husband, Sri Hami Nyang, was also present in the house and saw the incident, but he did not raise alarm as he was scared. Deceased number 1 was chopped on the head, and deceased number 2 was hit on the back of the neck. Now the corroboration part, my lord. Number 1, statement of PW2 stands fully corroborated by the statement of PW1, particularly her presence at the place of occurrence and witnessing the incident. PW2 description of the nature and areas of injuries are corroborated by the deposition of PW5 Dr. M. Pade, who deposed on behalf of late Dr. G. Pasa, who conducted the postmortem. So therefore, my lord, PW1 and PW2 has clearly described the nature of injuries, the area of the body where it was being attacked, and also the nature of the weapon used, my lord. And this stands corroborated by the statement of the, my lord, evidence of PW5, the doctor, my lord. And in the cross, nothing could be, my lord, contradicted. PW2 statement stand corroborated by the inquest report bearing the signature of PW1 as witness. So, my lord, in the statement of PW2, she had clearly stated that I had also signed as a witness my thumb impression in the inquest report. So, this also stands corroborated, my lord. So, she was examined after 24 years, not 20. PW1 after 23 years and PW2 after 24 years, my lord. Now, PW3,
Even then, quite clear. I mean,
very,
the way they
my lord,
narrated.
though they don't remember the exact date, my lord, but they still remember, and they are very, very, my lord, they still questions themselves why the accused had killed them, my lord. No reason, no prior enmity, you know. Now, my lord, straight away, my lord, page 3, my lord, PW3. In the examination chief, he deposed that on 15/5/1992, Sri Wambai Sulet, MDC, Saipung constituency, along with others, came to the PS and produced Edwin Sungo accused and reported that the accused had committed double murder on the night of 14/5/1992 at Sangpung. He had made GD entry by Joy PS GD entry number 500 dated 15/5/1992 and endorsed the investigation to in charge Rilang Outpost SIGS Walang PW6 and exhibited the GD entry as Exhibit 3, my lord. Number 4, I have read all these things, my lord, already. So I'll come to the legal aspect of the case, my lord. Now, my learned senior had raised certain legal objections, my lord, as to the maintainability of the conviction, my lords. Now, my learned senior had pointed, my lords, that PW6 had stated that he did not examine any witnesses, whereas PW4, who submitted the charge sheet, said that PW6 had examined 3 witnesses. Now, PW4 is right or PW6 is right, my lord? So, my learned senior had pointed to another aspect of the matter, that case diary was being used while passing the judgment, my lord.
Yes,
Case
entire
diary,
thing is based on case diary.
exactly, my lord. Now, my lord, the court below, my lord, went through the case diary to verify the veracity of the statement made by PW4 and PW6. PW6 is the actual IO, my lord. So, my lord, on going through the case diary, the learned court below had found that yes, indeed, 3 witnesses were being examined. I'll come to the legal part, my lord. Now, this has been reported, my lord, in the state of Dhanaj Singh versus State of Punjab, 2004, Volume 3, SCC, page 654. Also in 2004, SCC, Crime, page 851. And the relevant paragraph is paragraph 8, my lords. The stand of the appellant relates essentially to the acceptability of the evidence, even if the investigation is defective in view of the legal principles set out above. That pales into insignificance when ocular testimony is found credible and cogent. Further, effect of non-examination of weapons of assault or the pallets, etc., in the background of the defective investigation has been considered in Amar Singh case 2003, Volume 2, SCC 518. In the case at hand, no crack in the evidence of the vital witnesses can be noticed. What I am trying to stress herein, my lord, even if, my lord, the investigation to some extent is defective, but if the evidence of the ocular witnesses, my lord, eyewitnesses, is trustworthy and, my lord, goes to the very root of the issue, my lord, then defective investigation cannot be taken as a plea, my lord. Otherwise, my lord, there is a danger, my lord, for the court to play in the hand of the investigating officer, my lord. Another My lord, paragraph is paragraph 5. In case of a defective investigation, the court has to be circumspect in evaluating the evidence, but it would not be right in acquitting an accused person solely on the account of defect. To do so would tantamount to playing into the hands of the investigating officer if the investigation is designedly defective, my lord. Sometimes we have come across, my lord, cases where IO for his unexplained reasons, my lord, deliberately, my lord, make defective investigations, my lord. Now on to the point of, my lord, whether GD entry can be treated as FIR, my lord. It is reported in, my lord, CBI versus Tapan Kumar Singh, 2003, volume 6, SSC, page 175. Relevant paragraph is para 16, my lord. The party before us do not dispute the legal position that a GD entry may be treated as a first information report in an appropriate case where it discloses the commission of a cognizable offence, my lord. If the contention of the appellant is upheld, the order of the High Court must be set aside, because if there was in law a first information report disclosing the commission of a cognizable offence, the police had the power and the jurisdiction to investigate. In the process of investigation, to conduct search and seizure. It is therefore not necessary for us to consider authorities cited at the bar on the question of validity of preliminary inquiry and the validity of the search and seizure. So, my lord.
Yes.
So, my lord. So, in appropriate cases, my lord, GD entry can be treated as FIR, 7 except when it divulges, my lord, it discloses a cognizable offence. So, here is a case, GD entry is made, and in the GD entry, it is about twin murder. So, my lord, cognizable offence is made. Now, on the last occasion, my learned senior had also pointed to the fact that the weapon of crime was not recovered. To that, my lord, I'll draw your lordship's attention to the case of State of Rajasthan versus Arjun Singh, 2011, volume 9, SCC 115. Relevant paragraph, paragraph 18. As rightly pointed out by the learned advocate, additional advocate general appearing for the state, that mere non-recovery of pistol or cartridge does not detract the case of the prosecution where clinching and direct evidence is acceptable. Likewise, absence of evidence regarding recovery of used pallets, blood-stained clothes, etc. cannot be taken or construed as no such occurrence had taken place. As a matter of fact, we have already pointed out that the gunshot injuries tallied with the medical evidence. It is also seen that Raghuraj Singh and Himmat Raj Singh, who had died, received 8 and 7 gunshots wounds respectively, while Raj Singh, PW2, also received 8 gunshots scattered in the front of the left eye. All these injuries have been noted by the doctor. So, my lord, here is a case, my lord, when direct evidence, which is further fortified and corroborated by the medical evidence, my lord, then non-recovery of weapon of crime has no significance, my lord. Now, when the accused person was examined under section 313, my lord, his answer was simple yes or no, whereas he was duty bound to explain every evidence appearing against him, my lord. What does the Supreme Court say, my lord? In case of Virendra versus State of Madhya Pradesh, 2022, volume 8, SSC, page 668, last paragraph, my lord, last paragraph from the 4th, absence. Absence, failure of explanation by the appellant when the said incriminating circumstances was put to him during his examination under section 313 CRPC would work out against him. In these circumstances, the court below cannot be found in fault in taking it as an incriminating circumstances against the appellant. Now, on the nature of injuries, my lord. What nature of injuries, my lord? For that, I will straightway take your lordship to page number 8, my lord. Now, how to find out by the trial court below, my lords, as to, from the nature of injury, whether the accused had the intention the knowledge, or it was under certain provocation, my lord. It is for the courts to ensure that the cases of murder punishable under section 302 are not converted into offence punishable under section 304 part 1 by 2, or cases of culpable homicide not amounting to murder are treated as murder punishable under section 32. The intention to cause death can be gathered generally from a combination of a few or several of the following among others circumstances. Number one, nature of the weapon used, my lord. Here, the nature of the weapon that is used is one that can inflict fatal injuries, my lord. Second, whether the weapon was carried by the accused or was picked up from the spot. When my lord, in a sudden provocation, my lord, a person do not come ready prepared with the weapon, my lord. Whatever he gets in the place of occurrence, my lord, he will use that. But in a circumstance where he has brought a lethal weapon, my lord, with him, that means it points to the fact that he had the intention. So in this case also, my lord, he had come with the weapon, my lord, as described by PW1 and 2, the eyewitnesses. Number 3, whether the blow is aimed at a vital part of the body, that also matters. That is more important, my lord. In a heat of passion, my lord, sudden provocation, a man is blind with anger, seething with anger, my lord, he won't see where he is hitting, my lord. But this is a very, very calculative attack, my lord, on the vital part of the body of both the deceased, number 1 and 2. One on the forehead, my lord, 6 to 7 numbers of, my lord, injuries. 6 to 7, my lord, will mark that, my lord. Means, and injury size of the injuries are, my lord, 6 to 7 inches, my lord. Meaning thereby, my lord, each and every injury is fatal. The first injury itself was fatal to kill the person, my lord, but it shows his intention and the anger to kill the person, hence repeated attack, my lord. Number 5, whether the act was in course of sudden quarrel or sudden fight or free for all fight. Now, my lord, there was no fight here. He comes inside prepared, and unarmed person, my lord, are killed there, my lord. So therefore, there is no question of any sudden. So these are the circumstances, my lord, from where, my lord, the court below will come to a arrival whether the accused had the intention and the knowledge, my lord. In that circumstances, if both intention and knowledge are there, my lord, then a case of 302 cannot be converted into section 304, not amounting to murder, my lord. Now, my lord, on the point of minor contradiction, in the case of Birbal Nath versus State of Rajasthan, 2023, SSC online, Supreme Court, page 1396, relevant paragraph will be 24 at the bottom, my lord. When an eyewitness is examined at length, it is quite possible for him to make some discrepancies. No true witness can possibly escape from making some discrepant details. Perhaps an untrue witness who is well tutored can successfully make his testimony totally non-discrepant. But courts should bear in mind that it is only when discrepancies in the evidence of a witness are so incompatible with the credibility of his version that the court is justified in jettisoning his evidence. But too serious a view to be adopted, a mere variation falling in the narration of an incident, either as between the evidence of two witnesses or as between two statements of the same witness, is an unrealistic approach for judicial decision. So my respectful submission, my lord, here in my case also, my lord, where PW1, PW, all the PWs were examined after, my lord, more than 2 decades, my lord, 24 years, 23 years, my lord, and they too a rustic village people, my lord, illiterate people, they are bound to make, my lord, minor contradiction. And this minor contradiction does not go to the root of the issue here, my lord. Now, on the point of non-examination of the witnesses, my lord, on the last occasion, my lord, the senior pointed to the fact that, my lord, PW1 PW2 had stated that so and so also, my husband was also present there, and Iorita was also present there. She was 15, 16 years, but they were not examined. Now, my lord, this is reported in the case of Lalu Majhi versus State of Jharkhand, 2003, Volume 2, Supreme Court, SSC 401, relevant paragraph is 10. The law of evidence does not require any particular number of witnesses to be examined in proof of a given fact. However, faced with the testimony of a single witness, the court may classify the oral testimony into three categories, namely, wholly reliable, number 2, wholly unreliable, number 3, neither wholly reliable nor wholly unreliable. In the first two categories, there might be no difficulty in accepting or discarding the testimony of a single witness. The difficulty arises in the third category of cases. The court has to be circumspect, circumstantial before acting upon the testimony of a single witness. Now, my case is, so this citation says that, my lord, there is no straitjacket formula, my lord, or there is no law that says that a particular number of witnesses to be examined, my lord. When, my lord, quality and sufficient number of witnesses have been examined, my lord, so in my case, I have got two prime, my lord, eyewitnesses, my lord. So there is no need, because if other witnesses, they will be parroting the same thing, my lord. But in this case, my lord, the appellant has to show as to how they are prejudiced by not bringing of the other witnesses. But in the trial court evidence, as well as, my lord, in the appellate stage, nothing of that sort has been, my lord, brought to the notice of your lordships, my lord. Now, my lord, this is case of Ram Prasad versus State of UP, 1974, Volume 3, SSC 388. I'll be reading from last line, 7th line, my lord. The non-examination of these witnesses, in our opinion, would not introduce any infirmity fatal to the prosecution case. It is no doubt true that the prosecution is bound to produce witnesses who are essential to the unfolding of the narrative on which the prosecution is based. Apart from that, it cannot be laid down as a rule that if a large number of persons are present at the time of occurrence, the prosecution is bound to call and examine each and every one of these persons. The answer to the question as to what is the effect of non-examination of a particular witness would depend upon the fact and circumstances of each case. In case enough number of witnesses have been examined with regard to the actual occurrence and their evidence is reliable and sufficient to base the conviction of the accused thereon, the prosecution may well decide to refrain from examining the other witnesses. Now, my lord, PW1 and PW2 are related, my lord, are related to the disease number 1 and 2, my lord. So, therefore, my lord, on the last occasion, there was a submission made that they are interested witness, my lord. Coming to that, my lord, State of Rajasthan versus Kalki, 1981, Volume 2, SCC, page 752. Relevant paragraph is 7, my lord. As mentioned above, the High Court has declined to rely on the evidence of PW1 on two grounds. Number 1, she was a highly interested witness because she is the wife of the deceased. And number 2, there were discrepancies in her evidence. With respect, in our opinion, both the grounds are invalid. For in the circumstances of the case, she was the only and the most natural witness. She was the only person present in the hut with the deceased at the time of the occurrence and the only person who saw the occurrence. True it is, she is the wife of the deceased, but she cannot be called as interested witness. She is related to the deceased. Related is not equivalent to interested. A witness may be called interested only when he or she derives some benefit from the result of the litigation. So, my lord, now, lordship, the last point, my lord, that is absence. Here, my lord, when the evidence was collected in the trial court below, my lord, motive was missing, my lord, in the entire evidence. Now, coming to that, this is a case, as I earlier made a submission, my lord, this is not a case of, my lord, circumstantial evidence, my lord. Relevant, my lord, this is reported in the as early as 2012, my lord, in case of Chandan versus State of Delhi Administration, relevant paragraph, my lord. It is page 17 and 18, my lord. The last page.
Highlighted.
Yes, my lord. In Shivaji Ganu Mohite versus State of Maharashtra AR 1973, Supreme Court, page 55, it was held that it is a well-settled principle in criminal jurisprudence that when ocular testimony inspires the confidence of the court, the prosecution is not required to establish motive. Mere absence of motive would not impinge on the testimony of a reliable eyewitness. Motive is an important factor for consideration in a case of circumstantial evidence. So, my lord, my case is not a case of circumstantial evidence. So, in view of what submission, my lord, I have made, my lord, I would like to sum up, my lord. Here, PW and PW are the eyewitnesses. Their statement stands corroborated by the statement of PW6. So, this is a case of, my lord, twin murder, my lord, where the nature of injuries, the area of the body which was being attacked, the nature of weapon that was used is fully stands corroborated by the, my lord, the statement of PW5, which is the doctor, my lord, who has conducted the post-mortem, my lord. So, therefore, my lord, the impugned judgment passed by the trial court below needs no interference, my lord. That's all. Thank you.
Your Lordship, whatever submission has been made, with regard to non-examination, what are your statement that I did not examine any witnesses, that is very vital for me. That cannot be brought home the evidence of PW 1 and 2. PW 1 and 2, where from they came, where from the statement came. And another vital important is that the informant was never examined. The MDC, Sulet, was never examined.
Who's the MDC? But
Yes.
you said he died, I think, before.
No, he was never examined by the IO. Suppose I took an accused to the police station, I should be examined. This is a vital piece of evidence. How I incorporate him involving in the case? From where? That's the main root of the case. And the order said, if your Lordship sees, your Lordship will see that occurrence of 15, 14, 15 also didn't come, 16 night the police came. That time they make the inquest report, Exhibit 1 and Exhibit 2. And 16 night sent for the post-mortem examination. And the Supreme Court says that night post-mortem examination is not permissible. So those things has to be looked into, Your Lordship. IO himself said, I didn't examine. Then where from the Pala came that 3 witnesses examined? Where from he got it? Where the evidence? Let us see in the record. This is not there. No evidence. No 161 of any witnesses. Apart from that, there is nothing has been uttered by the prosecution about the case diary reliance. Whole judgment is related to the case diary. Based on the case diary as evidence. That is impossible, not permissible under the law. On that basis, the whole conviction has to be set aside.
You only have 2 authorities, correct? You're relying on 2 authorities.
Yes. Those two are the main authorities. Because case diary has been relied on as an evidence. On the basis, the whole judgment goes. Not to speak of any other thing. That's all my submission.
Have you filed any written synopsis of your argument?
With regard to the
Mr.
what?
Guru has, you see, Mr. Guru
He has given me
prepared-
that's all. With regard to motive. The question of motive,
With regard to the whole case,
or like this, I can give that.
it will be helpful. He's
Yes,
done,
I can.
he's done a very good way.
I can give that.
Prepare a written submission
Yes. I'll submit it by tomorrow itself.
and give
Yes,
the petition.
I'll do that.
In fact, the authorities that he has cited, if you have counter authority to that, you can cite.
What he has cited, because he's basing on PW 1 and 2. PW 1 and 2, where
I
from
have
it
supplied
comes?
the copies, my lord. I have supplied.
Yes, I'll give you those.
Supply by tomorrow. But tomorrow you can supply.
Tomorrow I can.
In the meanwhile, my lord, if I can come out with anything else also, my lord, it may be open for me, my lord.
No, your case is based on like overwhelming ocular evidence. That's the change of offence.
And not only
Yes,
that,
and
what
whether,
is
and whether you know the technicalities
My lord.
of a criminal proceeding can be overlooked in such cases where where there's corroboration and it's not a question of circumstantial evidence also, where we have to establish as to what is the exact nexus. That's the only thing. So we'll just examine the 313 statement again also, the records. With regard, because your case hinges on for the non-examination of the MDC also is
very important.
important in the sense, but whether looking
How
at the
he
case
bring
totality,
this accused there.
My lord, under such circumstances, my lord, the court has to see how the appellant is prejudiced. That did not come during the trial, my lord.
313 speaks of clearly. I didn't read the 313.
did
I thought
the defense counsel before that sessions court bring up these points also
No,
in the arguments?
No, it's not.
Because we have not examined. See, we've just taken up this matter as if we are sessions court only. We have not even examined the judgment of the sessions judge. I mean, we have not. You have not said where it's wrong or where it's right.
no, I have given
The only thing is that your
Case diary.
okay, on case diary, but we have not gone through the judgment of sessions court piece by piece. That is one.
My
No,
lord,
for the brevity of submission, therefore I just
My
gone
lord,
into
course,
that.
we
my
appreciate
lord,
that.
the law is very clear. If the prosecution fails to bring forward any witnesses, my lord, that does not debar the defense to call that particular witness, my lord. That was not done during the trial.
I will see. Anyway, you
Anyway,
supply, yes.
Otherwise, if your lordship wants me to go part by part, all paragraph of the judgment, I can go through.
It's just we have not touched that. It's the only thing. Yes, so just interested in seeing what is the defense, what
Yes,
they
yes.
did before the trial, before the sessions court. That's all. Yes.
Anyway, deeply honest.
Any mention?
My lord, there's
Yes.
one matter, WPC number 130 of 2025, my lord. My lord, I pray this matter will be listed tomorrow, my lord. I want to withdraw this case, my lord.
What's the matter about?
This is the other case where, my lord, the young man was discharged of the offence, and then subsequently he applied for recruitment, and they keep on asking him of charge sheet,
Okay.
FR, all this, my lord. Tomorrow. Obliged.
Lordship, I beg to mention item number 27, Lordship. This is the matter regarding Lordship. Lordship.
This matter is pending for the division bench of the Honorable Bombay High Court. We're just waiting for an outcome, my lords, because we've given a undertaking that we will not rely on the findings of the learned single judge. Some time may be granted, my lords. That is pending disposal.
Okay, after 2 weeks.
Lordship. So, pleasure.
To mention item number 22, Lordship. The conducting counsel, Mr. Shilla, is on medical leave, Lordship. Can you allow us some time?
What happened to him?
He underwent some eye surgery, Lordship.
Eye surgery?
Yes, Lordship.
The number 21, 22 together? No.
No, Lordship, only 22.
22 online.
After? 3 weeks.
3 weeks.
3 weeks.
Obliged, Lordship.
Obliged.
There is one item number 28, which is fixed today for hearing. Item 28, my lord. My lord, I am seeking your lordship's indulgence to make a mention of a miscase in that item number 28.
Is there 219?
28, my lord.
Yeah, and 28. A miscase number 219.
No, my lord. I am seeking to file a separate miscase today, my lord.
Regarding?
There's been, my lord, a declaration of result insofar as the post in issue is concerned, my lord. And my lord, there's an interim order passed by the Honorable Court saying that it won't, I mean, if any selection procedure has been carried out, it will not be finalized. But they have gone on to publish even the
What's
result.
the matter about?
My lord, this is with regard to the post of CDPO in the Social Welfare Department, my lord.
Integrated Child Development Project, Your Lordship.
Yes?
Integrated Child Development Project.
No, yes.
Your Lordship, but by last order, Your Lordship was pleased to direct me to seek instruction regarding what is the whether proposed amendment of the Meghalay's rule is finalized or not. So I have sent for getting instruction, but I am yet to receive instruction regarding this.
When did you send for instructions?
30th April, Your Lordship. 30th
April. Who's the officer who's responsible to give you the information?
It was Joint Secretary Social Welfare Department.
We'll call the person here if you they don't
Lordship,
listen to the
today
government
also
councils.
I send through WhatsApp message. One day time may be given. Your
Otherwise,
Lordship.
we'll call them here. If they don't, they're not getting cooperation, the court will direct them that they cooperate. And whenever instruction, they'll will come here with instructions.
One day time may be given because today morning I got the phone number and send it.
Otherwise, we can't have the court process just delayed because some officer is too busy to come and sign the paper or to not offer instructions. If not willing to do it, we'll know what to do. I've noticed that in many cases now for instructions you're taking 3-4 weeks or 2 months.
Your Lordship, I have
No, not in your case. In many cases. If that's the case, then we will streamline the process. What do you say, Mr. Shulai? Then
yes, yes.
you do not bothering to give instructions then? Yes. Yes, why you want to file this case?
Well, because
file it, yes. Within 1 week.
Oh, my lord, I am praying for today, my lord. In fact, we are in the...
Do some hearings first, then we will allow you.
My lord, in fact, that matter can be heard today itself, but since it's...
you do some...
Yes, that is why, my lord...
You're wanting you do some hearings from the list first. Eat the slow food, also not eat the fast
I have
food.
item number 32, my lord. You will do it today. My lord, may kindly have it tomorrow in that case, my lord.
File it. Otherwise, only... Yes.
May I please, Lordship. Lordship, I beg to mention item number 30, Lordship.
30?
30, Lordship. I'm praying for 2 weeks' time, Lordship.
Where's my Changresho? Why are you taking time?
There's some difficulties there, Lordship.
What's the matter about?
Renaming of the village, Lordship. Renaming of a village.
Karim Simshim?
No, Maria.
Maria of same shape, Lordship.
I'm appearing for respondent number 5.
Obliged, Lordship.
Yes.
May it please your Lordship. Lordship, I beg to make a mention of item number 24, Lordship.
Number?
24. I'm seeking for some time on this matter, Lordship. No objection.
Yes, 2 weeks. Yes. Yes.
Obliged, Lordship.
May it please your Lordship. Lordship, I beg to mention item number 26. Lordship, let this matter come up next week.
Why?
Because the conducting counsel is having some personal difficulties, your Lordship.
Personal difficulty?
Yes, your Lordship.
What's the matter about?
Well, this is school teacher, madam.
Sujata Das.
What school teacher? Lost the job or not getting salary?
I don't know, your Lordship.
You don't know?
This is regarding salary, madam. Show me. Where is the file? You didn't get the file?
Yes. Yes, yes.
All right.
Lordship, I beg to mention item number 33. After 2 weeks, your Lordship.
Why?
A movement is not well. A movement is not well, your Lordship.
A movement is?
Adaya, your Lordship.
What, a singer?
Yes, Lordship. Yes.
Okay. Yes.
Obliged, Lordship.
Mention item number 34, Lordship. Mr. A. Khan is not available today. This is because the similar matter has been dismissed by the Supreme Court because we are relying the judgment passed by the division bench of this honorable court, granting interest.
Supreme Court, that means it's
granting
in your favor or against you?
In our favor, Lordship.
Where's
Granting
Mr.
interest to
Eubin?
the.
This is a Mekofet matter?
Mekofet, Lordship.
Your Lordship.
Where's Mr. Eubin?
Just now he was
He is the main respondent.
Yes, Lordship. Yes.
You informed him?
No, Lordship.
Then?
Then let the matter be called.
Where's Mr. Eubin?
He's just here. He'll come here.
No, has he sought consent for adjournment? Because Mr. Khan is not there, so.
Yes, Lordship. Just now he called me. He just informed me.
You inform, you're Mr. Eubin's junior. You inform him with 2 weeks. Yeah?
2 weeks.
It was already disposed of Supreme Court, no arguments necessary.
Item number 1.
Yes. How's it maintainable, Mr. Sen?
Yes, my lord. Letter, I don't know. She will submit, I think. She has question.
Yes.
Lordship, I have challenged it for maintainability under section 7I, Lordship.
Yes.
Lordship, under, if I draw Lordship attention to
7I, you find out.
7I, Lordship.
Where's the order they agree with? Which one? Impugn orders?
My lord, I'm coming.
Impugn order. Are you seeing in an independent order only with interest, or it's a composite order?
It's not a composite order. This my case is. I have the
Lordship,
decision I'll rely on.
Lordship, it's
Impugn order 71 to 83. My lord.
Page?
Page 71.
Okay. Yes, Ms. Varasaji. You start.
Lordship, page 71 is the order
Yes.
under 14B,
Yes.
and interest is on page 77, Lordship, 7Q.
7Q is page?
Interest.
No, page?
Page 77.
Okay. 14B, page 71. 7Q. Yes. Start, yes.
Now, Lordship, under 7I, Lordship,
Okay, act. Yes. Yes, 7I. Yes.
any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the provision to subsection 3 or section or subsection 4 or subsection 4 of section 1 or section 3 or subsection 1 of section 7A or section 7B, except an order rejecting an application for review referred to in subsection 5 thereof, or section 7C or section 14B may prefer an appeal to tribunal against such notification or order. So here the main first contention is that, Lordship, here they have not preferred any review of our order. If they are aggrieved by the order, they have directly come before this honorable court. They have not preferred any review. Neither they have come as why they have not preferred. There is in the entire petition, no miscase, no extra miscase is also filed. Why they have preferred this petition before this honorable court and not went to appellate forum? At least there should be one miscase, so that citing the reason why they are not preferring appellate forum. There is no reason as such.
I mean, there are no pleadings in the main writ petition also.
In the main writ petition also, that why they have preferred this honorable court and not availed this tribunal. So when a statutory authority, when a statutory act has provided provision that first file a review of the order or of prefer an appeal if you are aggrieved by, then it is the responsibility of the petitioner to file a review of the order, stating that yes, your order, I am aggrieved by this or this provision of this portion of the order. Neither they have also preferred an appeal.
Yes.
To my understanding, the Lordship, to file an appeal, because recent some judgment has also come up from tribunal, wherein they need to deposit at least some of the amount to prefer an appeal. To avoid that amount to deposit an appeal, they have directly come before this honorable court.
There is no provision to seek exemption of depositing the amount before filing appeal.
They can file a petition. They can file a petition.
20% of the amount you have to deposit.
Yes. The tribunal has passed so many orders where the tribunal has also stayed the matters. Even your Lordship has also passed order where Lordship has given a temporary stay over the matter until go to tribunal. When the matter is pending before the tribunal has also stayed the matter till the proceeding ends. The proceeding, when the proceeding in the tribunal is on board, the adjudication is the adjudication process is on. They are not aggrieved by either. They are not aggrieved when the matter is already stayed. But why to prefer 226 rather than go to appeal the provision under 7I, the appeal provision? So my only contention is that since in entire writ petition, there is no ground that for what purpose they have come before this honorable court. Neither they have cited anything what made them not to go to appeal. Okay. So under this provision, they are for my it's not maintainable. For I am
praying that have statutory appeal remedy available.
Yes, Lordship.
Yes, that's it.
That's it, Lordship.
Authorities?
Lordship, some of the authorities are already, the Supreme Court has, through notification to all the Honorable Court, they have provided a standing order. Though it is under SURFACE Act, Lordship, but it covers up my case.
We understand SURFACE Act. I mean, regarding the 7I specifically, because they are 71.
Because usually in Supreme Court, all the appeals went through appeal, Lordship, as an appeal. Lordship,
But
there
is there a question of delay also, if they prefer appeal before tribunal?
Lordship, there is the delay.
Have they come directly to this court to beat the delay also? Is it beyond 120 days?
No, like immediately.
Is it within time?
Within time, Lordship.
Then, yes.
I'll satisfy.
Lordship, one more. This is under SURFACE Act, Lordship. Though it is under SURFACE Act, but Lordship, here it is paragraph.
Doesn't
32, Lordship.
Yes.
Lordship, we are therefore of the considered view that the High Court has grossly erred and in entertaining allowing the petition under Article 226 of the Constitution. Then paragraph 33. While dismissing the writ petition, we have reminded High Court to the following words of this court in the case of Swati Tandon. Since we have come across various matters where the High Court...
See, one thing, MS Bharsha, is that DRT, the Death Recovery Act and the SURFACE Act, they are, acts been put together by the legislature to facilitate speedy business, activity.
Lordship.
And also that they won't have the entire court process. Suppose you have to recover, or you need, installation, or you need resolution, or you go into liquidation. All those things are there.
Lordship.
Right.
Lordship.
So that's why the national, NCLT is there and the Death Recovery Tribunal is there. So when courts under 227 or 226 interfere, it short circuits the whole process. So suppose a bank has to recover something because some interim orders are operating, they prevent it. Leads to further losses, leads to other NPAs. You know what NPA is? So those kind of things, to avoid that, to ensure that there's a good business environment and climate. That's why they said once the statute provided appeal. But in the case of provident funds, different, because sometimes the 14B, the notice comes very late. Then the other issues. It's not a question of recovery of debts, or recovery or as under SURFACE Act. So that's different. I'm saying about authorities regarding appeal, not
Lordship,
not a general
Lordship here.
Not a general standing order.
Lordship here. Yes. One more thing is that Lordship.
Take out a judgment.
Lordship, in this judgment, Lordship.
Yes.
Actually, entire all over India, the High Court is entertaining the petition through appeal, Lordship, directly and not under 226.
Fine. Now show some judgment that says that on maintainability itself that sort of will answer your case, that there are two notices. One's under 14B damages, 7Q is interest. Right. Now when two orders have been passed, two impugners are passed, one for inflicting damages, the other for inflicting penalty, that the remedy will lie straight on the 7I only. It covers, the tribunal can cover the entire aspect, or whether he can bring up all the whatever grievances he has before the tribunal. Because sometimes composite order, yes, but if it's the order in isolation, maybe no. That's the only question that's before the court.
Lordship,
so just that you have to satisfy in that part. If it's composite order 14B7Q, then they have to go for appeal. But then if suppose interest is separated from damages,
Lordship,
then maybe we don't know. You'll have to assist the court.
Lordship, there is no other when one of the sections, when the order is passed under two sections, Lordship, if one section is appealable sections, on other sections there under 226 one cannot come, Lordship.
Yes.
So either they have to go since one section here, one section is appealable sections. For the interest part, they need to go to appeal for waiving of the interest, Lordship. Since I have checked almost all the orders of the others High Court or the Supreme Court, there is till now I didn't get as such.
Where's the order of this court? Any orders of this court? We didn't pass, correct? We just discussed it. In the other cases? In the
other cases, the Lordship has passed order to send it for appeal, Lordship, wherein the petitioner themselves has approached the Lordship's order only. Petitioner has themselves
No, that
approached.
there's no discussion because after they said themselves they would want to withdraw and to approach. So
Yes.
fine. You take out some other decisions. Yes, Mrs. Sen.
No, this respect, Your Lordship, 7I. Now, 7I very clear, my Lord. Now, 7I, my Lord, so far interest 7Q is not included. Not included. 14B, yes, my Lord, I am admitting, and appeal lies. Now, this situation has come up for consideration before the Supreme Court in context of these legislations. Now, Supreme Court, my Lord, has stressed on one thing. They say 7Q, don't take it lightly. Appeal is a creature of the statutes. I'll rely on that judgment. If it is not provided, appeal will not lie. But there might be a situation, what Your Lordship has just said, there could be a situation, there is a composite order. Perhaps even a composite order, you go for an appeal. But if the orders are distinct and separate, my lords, they said no. Court cannot, tribunal cannot, what is not provided to the tribunal cannot assume that power. That is 2013, my lords, if I can rely on that judgment. Just give him one copy. 2013. Just give 2013 only.
You given a copy? You kindly give a copy also.
Okay, I will give her my. Lordship will go to paragraph 17 onwards. Exactly the same issue came up.
17.
17 onwards.
This is 2013. It's not staple.
Lordship, if I can read it, madam.
Para 17.
Yes, ma'am.
Yes.
I'll just read. On perusal of the aforesaid provision, it is evident that an appeal to the tribunal lies in respect of certain action of the central government or order passed by the or any authority on certain provision of the Act. We have scanned the autonomy of the said provisions before, anatomy of the said provisions before. On a studied scrutiny, it is quite vivid that though an appeal lies against the recovery for damages under section 14B of the Act, no appeal is provided for against the imposition of interest as stipulated under section 7Q. It seems simply to note that section 14B has been enacted to penalize the defaulting employer as also to provide reparation or for the amount or loss suffered by the employees. It is not only a warning to the employee in general not to commit the breach of the statutory requirement, but at the same time it is meant to provide compensation or redress to the beneficiaries, that is the recompensate the employee for the loss sustained by them. The entire amount of damage awarded under section 14B except for the amount relatable to the administrative charges is to be transferred. Now this is important, my lord. 18. Presently we shall deal with section 7Q of the. It is as follows. The interest payable, my lord, this is the section. Now what the court has discussed thereafter. Provided that higher rate may be provided. 19, my lord, honor. Mrs. Apna Bhatt, learned counsel for the respondent, wanted through contend that the payment of interest by the employer in case of belated payment is statutorily leviable and is specified rate having been provided. The statutory authority has no discretion and therefore it is only a matter of computation and there cannot be any challenge to it. Be it noted, it was canvassed by the said respondents before the High Court that an appeal would lie against an order passed under section 7Q. On scrutiny of section 7I, we notice that the language is clear and unambiguous and it does not provide for an appeal against the determination made under section 7Q. It is well settled in law. The right to appeal is a creature of statute. For the right to appeal inheres in no one and therefore for maintainability of an appeal there must be authority of law. This being the position, a provision providing for appeal should neither be constituted too strictly nor too liberally, for if given either of these extreme interpretation, it bound to adversely affect the legislative object as well as hamper the proceeding before the appropriate forum. Needless to say, a right to appeal cannot be assumed to exist unless expressly provided by the statute, and a remedy for appeal must be legitimately traceable to the statutory provisions. If the express words employed in a provision do not provide an appeal from a particular order, the court is bound to follow the express words. To put it otherwise, an appeal for its maintainability is bound to follow the express words, bound to follow and explain why the right to appeal is described as a creature of the statutes. So, my lord, here is very clear and categorical, my lord. It has to be provided. If it is not provided, my lord, court cannot issue. Now, then a situation.
But the same day, 2 orders are passed. 27,
my lord, will it be composite?
Both orders been passed same day. Both 14B and 7Q. Now, can we consider a composite order?
My humble submission is not a composite order.
So, although it's placed in 2 sheets,
yes,
like one is served you on same day itself.
Computation is different.
Computed interest
different.
But then
I'll take your lordship.
Okay.
Computation is different.
Yeah, okay.
Lordship will see, my lord. 21, I'll take my lord to 21. At this stage, it is necessary to clarify the position of law which does arise in certain situations. The competent authority under the Act, while determining the monies due from the employee, shall be required to conduct the inquiry and pass an order. An order under Section 7A is an order that determines the liability of the employer under the provision of the Act, and while determining the liability, the competent authority offers an opportunity of hearing this. At this stage, the delay in payment of the dues and the common interest are determined. It is a composite order. To elaborate, it is an order passed under Section 7U and 7Q together. Such an order shall be amenable to appeal under 7A. The same is true any composite order, facet of which is amenable to the appeal under 7I of that. But for some reason, when the authority chooses to pass an independent order under Section 2, the same is not
very interesting
appealable.
Yes.
Same is not appealable. Now coming to the series. Now, my lord, here if your lordship will look into it, normally what
now examine the orders,
yes,
whether they're independent.
Yes, my lord, this is independent because what the Supreme Court has said that, my lord, the amount has been determined, and on the basis of the amount, my lord, the same order, what is the interest, that is also determined. Here it is not so. Here it is, my lord, damages. One part and altogether, my lord, different computation in another part, my lord, independent order, my lord, determining the interest. So it cannot be a composite order.
So that situation, your submission.
This situation, my lord,
it has to come before this court only.
I cannot go 14B, challenge it before the tribunal, then 7Q here, my lord.
That doesn't make no sense.
That makes no sense. So my humble submission, my lord, this is maintainable. Otherwise, my lord, yes, what my learned friend has said is correct. If it is a composite order or otherwise, my lord, normally it should be appealed. That is now the settled position of law. Other thing is there, my lord, of course, I came across a decision, my lord. Even if, my lord, an appeal is provided under, this is my secondary submissions. Even if it is otherwise provided, my lord, an appeal lies. But when there is glaring illegality, glaring illegality, my lord, prima facie illegal. Because here is a case, my lord, here is a case, my lord, they have shifted to online payment. Now, portal was not activated, admitted position, 2012.
That is a general.
That is also there, my lord. But then I am harping on this. My lord, when the law has been settled, my lord, and it's not a composite order, and it cannot be presumed and treated as a composite order in the facts and situation, my lord. And writ petition is maintainable, my lord.
Lordship, may I please, Lordship, if I can get the citation or a copy of the judgment.
We'll give you one more opportunity.
Yes.
Now you have to show there's not a composite order. Very interesting point because
I'll give.
Just because I have to see whether.
Copy then.
No, I'll give it.
Yeah.
No, Lordship.
Take the citation.
No, Lordship, it's okay. I
can
can
answer now only. Can you answer now only?
No, Lordship, I need to find out whether this order has been set aside or it's still pending, Lordship, because some orders, I don't know. On seeing the order, I have to find out.
I'll give a copy. But I did my research, my lord, whether it has been overruled or not. But anyway, she can find out. I'll give her a copy.
Yes, because post after 1 week for further hearing materiality. Yes.
Lordship.
Because now, if you have to show that it is a composite order. There is passed the same day.
Lordship,
and 2 orders are given to the petitioner. One 14B, 7Q.
Just for the what to my understanding, Lordship. Yes. Suppose, Lordship, there is a miscellaneous application filed in a writ petition, Lordship. Now,
we will consider your submissions also. Okay. There are no pleadings are there to show why these pleadings are not been given.
Lordship.
Yes.
But there is a miscase for stay. My lord, there is an interim order to continue.
Yes, after 1 week.
Interim order to continue.
For the hearing, interim order to continue.
Item number 2.
Obligement.
You come prepared next time.
I know what is
Lordship.
composite of
Yes. I mean, better prepared. Yes, Mr. P.T. Sama.
They're supposed to file the affidavit. This is the contempt. Actually, there is
Last time
appeal.
we said let it come after to await outcome to appeal.
No, they filed an appeal, but there is no stay actually. They are not complying.
Yes.
They are not complying with that.
Lordship, in this matter, appeal is pending.
Yes, so file
So,
affidavit. Yes, 3 weeks time allowed to the respondent file affidavit.
Much less Lordship.
Mr. Changreso.
Yes, madam.
According to where's the counsel for the where's Mr. Sen? Oh, you're appearing, sorry.
My friend is appearing.
You took part in inquiry?
My lord, we have taken part.
Then?
Petitioner has taken part. And after taking part the inquiry proceedings, before furnishing the inquiry report, they have passed the impugned order. And after passing the impugned order, they try to serve the inquiry report.
You challenge it. Now we have other requests.
My lord. So in fact, if lordship set aside the impugned order and give me a copy, then I will face the my proper representation. But that is the law.
We can't have that. We can't have that because see the other developments. We can't have that. What do you call
May I
it?
just show a few annexures?
Because the inquiry report is dated 16 September.
I'll show it.
And the impugned order is 19 September.
Yes, that is true. That is true. Lordship, can you see page number 25 of the writ petition? This is the first show cause notice issued to her.
No. Let's go to inquiry report. Where in the affidavit?
Inquiry report will be at page 40.
You dated?
Dated 16 September 2024.
And when was it handed over to her?
Lordship, the impugned order is dated.
Impugned order, my lord, in my writ petition, page number 41,
Page
19 September.
19 September.
And my lord, on their own admission, affidavit page number 46,
Once again.
managing committee tried to serve the copy to her on 20 September. When she was on medical leave.
So only for charge you're fighting?
Madam?
Only holding charge?
She's holding additional
Madam,
charge.
she was appointed as headmistress.
She's getting extra remuneration of only rupees 2,000 now. She's still continuing as a teacher in the school.
That is true, but if we go by the act, my lord, any demotion requires prior permission also.
Okay.
Lordship, can you see page number 46 of the affidavit?
Yes.
This is the letter issued to her
Yes,
when she was on medical leave. And my lord, we see remaining pages, page number 50 onwards. They also tried to send through postal service.
She refused.
Well, 25, page number 50 onward of the affidavit.
1 second.
Of the managing committee affidavit. Page number 46 is the first letter issued to her. Date 20, after passing the impugned order.
See, one thing, Mr. Chari, so when you came for this court, you said that you were not heard, correct?
Yes.
But inquiry was conducted, ma'am. Therefore, we
inquiry, you did not say that you took part in inquiry. When did you file? You filed in 20 September.
I do admit.
The inquiry took place on 16 September, where you took part.
Well, I'll just show
see, see para 22 of your writ petition.
Yes.
See para 23. 22, you say that impugned action taken by demoting without issuing show cause or giving possibility to submit an accurate representation to rebut whatever finding arrived at by the respondent inquiry committee.
But
you're aware of the contents of the inquiry report at the time when you came before this court. That means.
But the pleading is not that sufficient to explain. I to admit.
No, I mean,
but
what it conveys is that
the substance.
What it conveys is that you said that first you not get a positive, but you know that that adverse finding was arrived against you.
Inquiry itself was adverse to her. Therefore, because of that.
No, 22 you said that.
And 23 might not be
issue was not effective to rebut adverse finding arrived at by the respondent inquiry committee in the report. See, so the writ petition itself, you're already aware of the contents of the report.
Right
or wrong?
She was not aware.
Then how you written the writ petition that you're aware? You kindly read para 22. On this pleading itself, you have to dismiss your writ petition, Mr. Chanriso.
Well, 22 and 23, if we read,
you kindly read. See, this is just, I saw just now.
Submit that the impunity action taken by the MC, demoting the petitioner from the sanctioned post of such, carrying addition such, to lower sanctioned post of the teacher, is such, without issuing show cause. Notice given opportunity to the petitioner to submit her effective representation. So this with regard to my lord, she was aware that my lord.
No, read the other next sentence.
To rebut the adverse finding arrived at by the responding inquiry committee in its report amounts to pride in violation of the subtle self-possession of process as principle of natural justice.
In this report,
my lord, she was not received, but because of the nature of the adverse.
No, you already said it in this report. You already seen the report. That means.
But it was not, my lord. They do admit.
Otherwise, we will pass orders. Yes.
My lord, even my lord, an action given by the respondent, it clearly shows that they did not give copy to her. After 20 only.
Assisted by Mr. Tita Khat. Also, Mr. Emil Nong Pure. Stop. Will dispose it off, Mr. Chaniso? Otherwise, you see, you have a opportunity to. The thing is that now, what you've on the pleadings itself, you've said that your report is already received.
In that case, may I just pray, my lordship indulgence, allow me to withdraw a liberty given to her to challenge the inquiry report.
Yes, that's what it is. At the course of hearing, Mr. H. Chariso praised that submits that as the inquiry report has since been obtained by the formal copy of inquiry has been obtained by the petitioner, he may have to withdraw and to file afresh is to advise. Praise allowed, matter stands closed to withdrawal. Yes. Deputy has prayed.
Order must stand vacated.
Yes, all interim orders shall stand vacated. See, Mr. General, because not to the council, I mean, the pleadings are there clearly. That is why and we have to go by pleadings on affidavit.
Should be elaborated.
You already received the report.
I must.
Yes.
Deeply obliged.
Yes, Mr. Sheikh.
Lordship, I'm praying for some time in this matter, Your Lordship.
Why?
Miss, our colony is unlike in courtroom 1, Your Lordship.
What's the matter about?
This is here, Lordship. The pension has been stopped, Lordship, since 2019, Lordship.
Oh yes,
regarding that treasury matter, because the treasury officer is not giving any details to the pension sanctioning authority, Lordship.
Just tomorrow in the supplementary list. Will you tell her they'll dispose of tomorrow?
Yes, Lordship. Oblige, Lordship.
Item number 5.
Absent MSR only list the matter tomorrow in the supplementary list. Orders here.
Oblige, Lordship.
Yes.
May please, Your Lordship. Your Lordship, I'm praying for some more time for respondent 4 and 5, Your Lordship.
ZE non-complete for?
1, 2, 3, Your Lordship. We have filed
4 and 5 is whom?
A private respondent, Your Lordship.
Your Lordship, the state respondent are to produce the documents, Your Lordship.
Your Lordship, on the last day the matter was heard, Your Lordship, we said that the records will be produced at the time of hearing.
But we need it for perusal, Your Lordship. Otherwise, you can't reply.
Suppose you don't allow you to peruse it? What's the matter about?
This is the inter-seniority case, Your Lordship, in the department.
When are you going to file affidavit? You already filed it.
I filed, Your Lordship.
2 weeks' time may be given, Your Lordship.
You are the private respondent. What post is
Yes,
this?
Your Lordship.
Assistant
Engineer, Your Lordship.
LDA?
Assistant Engineer, Your Lordship.
This is regarding this...
inter-seniority, Your Lordship.
They're challenging the gradation list, Your Lordship.
You have 5 and 4 and 5. patiently stoned. Yes. When did you enter appearance?
Just last order, I think. Oh, you check.
Yes, 11/3. You should have filed by now. A further 1 week's time is allowed. For prior respondents, the main response is the state.
2 weeks, Your Lordship.
Main response is the state because, yes, a further 2 weeks' time, yes. Or there's the last opportunity to file affidavit by response 4 and 5.
Much obliged, Lordship.
Item number 6.
Please, Lordship, this item number 6, Lordship, was supposed to affect service for the respondent number 7. Lordship, I may pray, Lordship, allow us to serve through dusty service, Lordship.
Mr. Idakhat will please and we allowed to affect notice by personal service upon number 7. You appeal for number 7? Yes, prayers allowed list up to 2 weeks.
Item number 7, Lordship, is connected.
Just together next date.
Here I am appearing for 8 to 18, Lordship. For private, 8 to 18.
Here, Lordship, the respondents state of Assam has not entered appearance, Lordship.
State of Assam, why?
4 to 6, Lordship, the respondent 4 to 6.
Why is it Assam's a party?
Because here, Lordship, we are challenging the certificate which was issued by the institution which was fake, Lordship, which is not recognized.
They've been served?
Yes, Lordship. We have filed a service affidavit also, Lordship.
You file affidavit?
No, Lordship, I'm free for time, Lordship.
Number 7. Number 7, Mr. Idakhat surfaced that those servers been affected upon 4, 5, and 6. There is no appearance on their behalf today. Next, Mr. S.A. Sheikh for 7 to 18.
8 to 18, Lordship, not 7 to. 7 is my friend, is it?
Oh, yes. MSM Rahman is present behind number 7. There's also Mr. S.A. Sheikh for respondent number 8 to 18. You file affidavit? No.
Not yet, Your Lordship.
For Thoshwa, MS Ailingwa for 1, 2, 3, M. Rahman for 7, and Mr. S.A. Sheikh for 18. Please phone allowed for the 2 weeks time for affidavit. Stop fresh notice to be steps to be taken for serve notice on the response 4, 5, and 6. 3 days. This up to 2 weeks.
Lordship, if I may pray, Lordship, this matter can be listed on 3rd June, Lordship, along with that pending matter, Lordship.
No, that is different, Lordship.
Connected, Lordship. They have a bearing, Lordship.
Because
okay, let's on 3rd June. We'll
3rd
see.
June, Lordship.
Not that we tag it together. Let's on 3rd June.
A lot of confusion because of that. If the matter is tagged together, Lordship.
We're not tagging it together. Let's on 3rd June.
Obliged, Lordship.
Item number 8.
The case hearing has been concluded. I have filed a bullet point.
What about the petitioner? And Mr. Marpan?
Yes.
Yes. Good point been filed. Judgment reserved. We'll pass
Your Lordship, one more thing. The record is here. I think Your Lordship required the record because I'm giving reference to that record. I'll give the record. It may be reflecting the order.
Mr. Marpan submitted the break points for respondent number
1 to 4.
1 to 4 along with the records.
All right.
Hello, pleasure.
Item number 9.
On behalf of the state, we are praying for time counter.
Six and 7?
6 and 7 hasn't appeared, Your Lordship.
Yeah, 6 and 7. 6 and 7 is whom?
Nobody appeared, Your Lordship.
Who, no, what 6 and 7 are?
It's a private respondent.
Managing committee and?
An ex officio and 6 and managing committee and Mujida Begum, headmistress.
They have been served.
Your Lordship. Lordship, we have filed our service affidavit on 13th of March, Your Lordship.
20th of March.
March. I pray may the may proceed expert, Your Lordship. Because
Mr. Keeper, where's your affidavit?
My lord, I'm praying for time.
Your file?
No, my lord, I'm praying for time.
When did you receive instructions?
My lord, we have received one recently also, my lord. 2 additional instructions we've received.
What about Mr. Kriyam? Appearing for spot number 8. Ahidur Islam. You file affidavit.
We
We'll
received,
give you 1 week's time to file
we received
affidavit.
on the end, during the end of April, my lord, we've received. So I'm praying for 2 weeks. My lord.
Any urgency?
Lordship, here our prayer is for to release the salary, Your Lordship, on payment of salaries and to conduct a fresh inquiry.
Yes. This matter has been filed since last year. Yes, final opportunity of 2 weeks allowed to the state respondents as well as respondent number 8 to file the affidavit. Stop. Next one, MS M. Rahman submits that the respondent number 6 and 7 have been served since March 2025, and affidavit has also been filed on
13th of March.
indicating service. Have been filed on
13th of March.
13th March 2025. Stop. Accordingly, with regard to respondent number, they are 5 and 6.
6 and 7. 6 and 7.
Matter shall proceed ex parte just after 2 weeks for further orders
Your Lordship.
and for affidavits.
Your Lordship.
Item number 10.
Bless Your Lordship.
Please, Lordship. Lordship,
Can take appearance on behalf of
Lordship, on behalf of the
Kalyan, huh? Yes?
or Contempt, no, Lordship.
Soul.
Yes,
Yes,
Your Lordship.
Yes, Mr. H. Karanlang entered appearance today on behalf of the sole respondent. As such, notice is complete. He prefers allowed
Lordship, Lordship, may please grant 3 weeks time, Lordship.
2 weeks time.
3 weeks time, Lordship. Lordship, I've saw instructions, but then the Contempt, the respondent is under bereavement, Lordship.
Okay, these are the 3 for affidavit.
11.
My lord, the petitioner has not received any communication from the respondents, my lord, with regards to
You
even.
joined from September, you have not received any communication?
No, my lord. No, my lord.
Dr. Moisika, is that a fact?
It's let them file this instruction by way of affidavit when they have communicated, my lord. And second aspect, my lord, back wages. The
Back
petition.
wages will come secondary.
My lord.
Now, why you not? How
My lord, in fact, is liable for further disciplinary proceeding for not joining. My lord.
My lord, let them file an affidavit, my lord.
Just to cover that part, my lord, he is coming for the Honorable Court.
Can you show your dark register?
My lord.
I'll
Or
place
if, otherwise, Mr. Jha will become
My lord, definitely,
fall
ma'am.
very heavy on you.
My lord.
If you're a petitioner, rather, if he is aware that he's been reinstated, that order's been recalled, and then he's not joined.
My lord, if that be so, my lord, in November 2024, he has filed the statutory appeal. Why he will burden himself for approaching this honorable court, my lord?
Today, Mr. Jha submits that the order dated 11 September 2024, reinstating him to service. No, Mr. Jha submits that the writ petitioner does not have any knowledge about the recall of the impugn order dated 31st May 2023, correct?
By the order
And
dated.
his reinstatement to service, as has been communicated by an order dated by letter dated 9 May 2025, addressed to the DSGI, which is produced for this court. Stop. In this view, the matter, the learned DSGI is directed to produce, what do you call it, a dark register?
My lord, even the
It may be through post also. My lord. I'll file an affidavit.
To file an affidavit indicating that the order of the Deputy Inspector General setting aside the summary Assam Rifles Court proceeding in respect of the petitioner. Indicating the fact that to apprise the court the fact as to the setting aside of the summary Assam Rifles Court proceeding against the writ petitioner. When you will file it?
A week's time.
Yes, just after 1 week. If that's correct, if any signature appears anywhere, Mr. Jha, we
My lord, it's prima facie, so this is an order, my lord. There should be, if had it been, my lord, it would have been addressed to the such and such person.
Have you got a copy now? No, that fourth is a communication. The earlier is an order of the summary.
My lord, it is just an order, my lord, where it has been addressed to the petitioner, my lord, communicating this order.
Okay, let them produce.
My lord, my lord.
If not, then served. Number 5.
Yes, Your Lordship.
Your Lordship, I'm entering appearance for respondent number 5.
Oh, very good. 5.
Yes, Your Lordship.
Ms. Shows entered appearance today on behalf of respondent number 5. As such, service complete on all the respondents. Then?
We'll file a affidavit, Your Lordship, after 2 weeks.
But I have also received soft copy only on Friday, my lord.
4.
Lordship, I have received instructions, but I have to seek clarification because there's some.
Okay, respondents pray for allowed further 2 weeks time to file affidavits. This thereafter.
13.
Please, Your Lordship. Your Lordship, in this case, the state affidavit is ready, but because there were some mistakes detected, Your Lordship, we need another 2 days' time to file it.
Yes, as paid for the 1 week's time allowed to the responsible file affidavit.
14.
14 here. Here we have filed the affidavit.
Your
The
Lordship.
state-
Your Lordship,
Yes.
respondents number 2, 7 and 8 have filed their
270.
affidavit.
What about 1, 3 and 6?
Your Lordship.
What about 1, 2, 3? What about 4? 4's whom?
Who's been?
4 is?
These are the petitioners. 18 only.
Kenija Rishiri. I don't. You are appearing for. Oh, many respondents are there.
Your Lordship, here they are.
They all been served.
All the respondents have been served, Your Lordship.
They've been served.
Your Lordship.
But none appeared for them. 2, 7 and 8.
Yes,
This is a state. Your Lordship.
Okay. Now what about the others?
Now,
Oh, how many respondents are there?
Your Lordship, there are
1,
8.
3 and 4, I think.
Only 8.
4, 5.
Respondents. 8 respondents.
General manager.
Number 2. 1, 2 and 8.
2 have filed, Your Lordship. 2, 7 and 8 we have filed, Your Lordship. 7 and 8 have filed.
Okay. Now, Mr. Dr. Mosika appearing for 1, 1, 3 and
I think even 5,
4 and
1, 3,
2 to 6.
Yeah.
1, 3 to 6. Okay.
I think
That
that
makes
covers
sense.
everybody, Your Lordship.
Yes. So, MST any then EAG submits affidavits has been filed on behalf of 2, 7 and 8. Dr. Mosika on behalf of the other respondents. That is 1, 3 to 6. Pray for and allowed for the 2 weeks time to file affidavits. This is thereafter and so on.
15.
Lordship, I filed my rejoinder.
Yes, we'll dispose today.
Your Lordship, you can come up for hearing, Your Lordship.
For hearing, Your Lordship, after a week.
Small point only.
Yes, Your Lordship.
Okay. On the prayer of parties matter for hearing also. Otherwise,
16.
you already signed the service book. Correction of age at the last fag in.
Lordship, I have relied on some document which the state has remained silent on that, so I have to press.
Okay, you hear it then.
Highly obliged.
Much obliged, Lordship.
Sixteen is for affidavit. Bring for some more time.
This has come first time is Dr. Mozika, so the SGI pays for the 3 weeks time of affidavit.
17.
17.
17 also.
17.
18.
Lordship, I have taken step, Lordship.
Yes, Doctor.
Representative for respondent 1 to 3, Your Lordship. I may be given some time to file my counter, Your Lordship.
How long?
3 weeks, Your Lordship.
Officer indicates that AD cards not service not complete on response 4, 5, and 6. Stop Mr. H. Abraham on behalf of respondent to pre-place for allowed 3 weeks time for affidavit. Just after 3 weeks for affidavit for service report on respondent number
456, Lordship.
Very good. Yes.
19.
Lordship, in 19 we have received instructions. The work charged service which had been rendered by the petitioner has been regularized. So his grievance has been redressed, Your Lordship. The matter can be disposed of.
Yes, go to number 1, Lordship.
Your Lordship, I just...
You file your instructions or you just produce them?
This is
next day, Your Lordship.
the letter is here with
After
us, Your
1 week,
Lordship.
yes. MST Yangi submits that the petitioner has since been redressed as much as the time spent as
Work charged employee
has already been regularized. She prays for us this after 1 week.
20.
Due to the absence of Mr. P.T. Sama.
Your Lordship. Your Lordship, I maintain appearance on behalf of respondent number 3. What is happening? A corrigendum is being issued by the Joint Secretary to the Government of Meghalaya, Health and Family Welfare Department. This is a corrigendum. I've given a corrigendum. In view of this, the case doesn't subsist.
This was before the case was filed?
Yes.
Oh no.
Means actually what happened, the advertisement was for the associate professor and the result declared for the assistant professor. That is the ground. Now assistant professor has been corrected as associate professor. She has joined as a associate professor.
By affidavit.
Yes, my lord, I will bring it on.
Mr. S.V. Mantat entered appearance today on behalf of respondent number...
On your respondent number 3.
Number 3. Such notice is complete on all respondents. Stop. It is further submitted by the Mr. N. Sincon. Who produces? You or who produces?
I'm producing.
We are a government respondent, yes. It is submitted by Mr. N. Sincon, learned GA, that a corrigendum has since been issued on 16 May 2025, clarifying the designation mentioned in the advertisement. So we place funds allowed to place the same with affidavit.
I've given a copy at once.
Yes. You take instructions also.
Much obliged.
Hearing 21.
You've heard of the song Down to the Waterline?
My lord?
You've heard of the song Down to the Waterline?
No, my lord.
No, but I straight, you haven't heard. See, you don't follow music.
I love music, but some other gentlemen.
It is within the prohibited limit or permitted limit?
I'm going to see
I was just in doubt with regard to one provision, my lords. If Lordships will have the guidelines of 24, the amendment. So they're otherwise outside the prohibited limit.
Where are the guidelines of 24?
24 is the amendment, Malad. The original guideline was 23.
13 February.
Malad?
13 February 24.
Yes, 13 February 24.
Yes.
Please look at para 2 at the bottom.
Insertion.
Insertion of subparagraph in para 7. In the principal guidelines in paragraph 7, after subparagraph 1, the following subparagraph shall be inserted, namely 1A, width of regulated zone for a water body shall be 4 times the width of water body setback for such water body applicable for water bodies mentioned in Appendix 1 and Appendix 2. My lords, we'll just, for this purpose, just have the guidelines of 23 to see the definitions.
At the schedule. Appendix.
Not the appendix, my lords, just the definition at para 2 of the 23 guidelines.
Yes.
So first it refers to width of regulated zone, my lords. Regulated zone is defined in C. 2C. Means individual plots of land located in immediate vicinity of the, it says no construction zone, but this has been amended by the 24 guidelines to read as water body setback. So it would read means regulated zone means individual plots of land located in immediate vicinity of the water body setback where construction of building and other structures shall be regulated in the manner provided in, and instead of para 5 they should read as para 7. Now please see water body setback at F, 2F. Water body setback means an area located in immediate vicinity of the mean high flood level of a water body observed in the past 10 years where no construction of permanent nature except the structures and activities specified in para 4 shall be permitted. So now if your lordships look at the appendix 2, so at serial number 2, my lords, we'll see in the first column, the second column, more than 4m, this is the width of the riverine water body. In our case, the width of the river is 21.58 meters.
Yes.
Then the next one is the size of the adjoining plot. In our case, it is within 500 square meters. It measures 245 square meters. And lastly, the extent of water body setback is 17.21 meters. So he's outside that prohibition. Now the only problem here, my lord, is if your lordships come back to that amendment of 1A in the guidelines of 24, where under para 7 they've inserted a new clause. So it says width of regulated zone. So regulated zone is what falls outside the setback area. So they're saying the width of the regulated zone for a water body shall be 4 times the width of the water body setback. In this case, the water body setback is 17.21 meters. So now the rules require
Where
that
is 17.21 meters?
As per the report. No, in the appendix,
on the report specific to his
in
case.
the report, in his case, the property falls, the distance between the property and the water body is 17.21 meters. Now 1A requires that the width of the regulated zone shall be 4 times that of the width of the water body setback. So this, we don't have this information. Moreover, my lords, I don't think this is necessary because this will unnecessarily create more difficulty for the petitioner's construction. And furthermore, these guidelines are all prospective in nature. His construction came up way before. So lordships may consider their case. The reason why I'm pointing this out, my lord, is because there should not be any question with regard to the application of 1A. Because apart from the petitioner's property, it seems there are several other properties as well.
He succeed confusing the court.
No.
That's all. That's the only thing. 1A.
Yeah, my lord.
Amendment 1A, okay. Insertion subparagraph in paragraph 7. Now you say 7 in the principal notification,
lordship,
deals with
regulation of activities in regulated zone.
Right. Fine. Now you say.
So under para 7, they've inserted 1A.
Yes. Where a regulated zone for water body shall be 4 times the width of the water body setback.
Lordship.
So now water body setback, in this case, it's a water body less than 500 meters.
Lordship.
So they measured 17.5 meters. So now, like in his case, if you apply strictly 1A, what will be the regulated area zone for water body?
17 point whatever into 4.
It will be more than 60.
It will be
It's not
huge, more than
reasonable.
60.
It has to be 60 meters away.
60 meters. That's what, which
No.
is why 1A is very confusing, my lords.
Not reasonable at all.
Well, there's a minimum prescription in his case is 15. If your lordships look at that, minimum prescription of the water body setback for properties under 500 square meters
Water body
is 15,
yes.
15 meters.
15 meters, yes.
So now by reading 1A, it says the width of the regulated zone shall be 4 times the width of the water body setback. So if we apply the minimum, that is 15 meters, it comes to 60. The width.
Get it, but then it makes no sense.
Yes, sir. I don't know why they've introduced this. There must be some purpose.
With the rail zone for a water body, setback shall be 4 times the width of what is setback for such one. So now you mean to say all future constructions that if it is 60 meters, if it's less than, if
we go by 1A.
if it's less than, suppose it's 700 square meters, it means 25 into 4,
Lordship.
That'll be 100.
Lordship.
Then if it's 0.700 square meters like Barapani Lake or something, it'll be.
My lord. Then it's 25 into 4. And it is just talking about.
Barapani will be 50 into 4, be 400 meters.
400 meters. Extremely
200 meters, sorry. 200 meters.
200 meters. So it's only talking about the width, not even just not. They're not concerned with the length, but the width of the property.
The width of the lake or the water body.
No, my lords. Width of the regulated zone. Regulated zone is what falls outside the water body setback. So the setback is the distance.
Exactly. Now water body is here. So if it's now they amended, like suppose before a smaller water body up to 500 square meters, 15 meters setback. Now they multiplied into 4.
Yes.
So it's now will be 60.
No, not the water body. Water body setback will remain 15.
No, the water body setback. I mean, you can construct only 60 meters near the water body.
Yes.
That's what it means. Correct.
No. I'll just explain this again. So water body ends here. The setback is here. This is 15. Now what is beyond is the regulated zone. That has to be 15 into 4. The width.
So the regulated zone comes from. It's multiplied by 4, that means.
Yes, that's why it's saying width of the regulated zone shall be, for a water body, shall be 4 times.
What will happen to extend the water body setback then?
My lord?
What will happen to extend the water body setback?
That remains static. That will remain the same, because what they're saying is
now
the width
regulated zone for construction.
Yes,
you take permission for that part.
Yes.
But regarding setback, it remains the same.
Setback remains the same. That has not been touched.
It has to be clarified. This.
My lord.
You make any sense out of it, Mr. Shongwan?
It does not make sense, my lord.
That's how the rule reads, my lord.
I've tried from the very beginning. That's why on the
I found it confusing myself. What was the necessity to increase the width of the regulated zone? What can be the possible purpose? I understand if they increase the setback, but the setback remains static, but the regulated zone width increases.
When was the construction finished?
22. We started citing 22. And the first principal rule came in 2023. Now the amendment came in 2024. Now, my lord, if all the rules are being implemented retrospectively, no one will be safe.
No. It's not a question of prospective implementation, but just to understand, because we cannot pass an order will be like a precedent.
No.
That would sort of will regularize other unauthorized constructions which might come up with regard to definition. That's why this was trying to understand. Why is it, you can't find any clarification? What does it mean by why increase the regulated zone? It's for building permission.
We'll have to take instructions because we've asked the department. They are also not very clear because this was drafted by during somebody else's tenure. So what was the reason behind this? We failed to understand.
Yes, take down the vexed question VXED of assessing the petitioner's case along the lines of the permitted extent of water body setback has come for consideration again today. Stop. Next paragraph. Mr. S. N. Leonard, government advocate, submits that though the petitioner's construction as per Appendix 1 of the notification dated 25/8/2023 falls outside the prohibited zone.
It'll be Appendix 2.
Appendix 2 of notification also falls outside the prohibited zone, which is 15 meters. He has also referred to a notification dated 13 February 2024, which modifies the earlier guidelines, wherein an insertion, namely section is a section,
Paragraph.
a paragraph, capital 1, where a paragraph, namely Roman 1, not Roman, sorry, Indian 1 and capital A. It has been prescribed that the width of the regulated zone for a water body shall be 4 times the width of the water body setback. For such, it's so strange. So water body is mentioned 4 times in one sentence. M1A. It prescribes that the width of the it's a copy, you know, quote, written quotes, okay? Yeah. That's a quote, Yes, those are quote, right? Anyway, as there is some lack of clarity with regard to what will constitute a regulated zone for a water body, you is permitted to obtain further instructions. Otherwise, your case will go in your favor. Don't worry, but just to get some clarity, yes. List of tweaks. It's not getting anywhere. Yes.
23.
Yes. How much money you'll pay them?
Your Lordship.
The same one, the payment of fixation
yes.
of money, no?
Yes, Your Lordship. Your Lordship, our contention is that the petitioners were not in service since January, Your Lordship. And they were informed verbally also, Your Lordship, of the discontinuation of their services.
Where's Mr. Shulai?
He's on legs, Your Lordship.
We'll pass order in his presence. Visit tomorrow. Yes. You'll ask Mr. Indy Shulai and then AG. This is a matter of tomorrow and self-produce. Tomorrow you come with
25.
Obliged, Your Lordship.
Yes, pursuant to the order dated 24/4/2025, a registry of this court has forwarded a copy of the order to the Ministry of Education. However, there is still no response. List, when was it sent?
25th April.
I see. Yes.
It is delivered.
And Thomas? 20 and 24 for her. To the Ministry of Education on 1/5, and the same was delivered on 1/5/2025. You got instructions?
No, sir.
Yes. However, today also Mr. Abdelnab submits that they are still yet to receive the instructions. Are you in this matter? You're in this matter?
The university.
Respondent number 3.
Yes, we'll list after 2 weeks and after we'll pass orders.
Yes, Your
After 2
Lordship.
weeks to,
Yes, Your Lordship.
to wait effective response, feeling which other orders will follow us.
Master.
28.
28 already called.
Yes, okay. Record the presence, Pooja Agarwal.
28.
May I please, Your Lordship? In this case, though Your Lordship has already passed order, but just now I went down and received the instruction.
You went down where?
Down our government room is downstairs. So, Your Lordship, no hope. It is lying with now. They are saying it lying with personnel department. Now again, I have to communicate to personnel department also. It is just from one department to other department.
Who's the SKRM? You receive also notes copy given to you also.
I have just now received.
So what to do? This case becomes infructuous before filing also.
We can, since we have already made a mention in the morning.
Let's listen tomorrow. That's the matter tomorrow.
But Your Lordship, I beg to submit that in the when that order was passed, Your Lordship, I was not aware of this. Only last day I came to know that that order is.
You were not present that day.
No, Your Lordship, our learned AG assisted by Mr. KP, but an order was not forwarded to them also, Your Lordship.
Yes.
So inadvertently, I think so.
Let's give a receipt and forward order to them.
Only last day when I mentioned to the court, I have obtained the order.
Lordship, this matter is all about for one increment, Lordship.
Where did you appear last time?
Lordship, it was I was within the vicinity of this honorable court, but the matter was taken up in the second half. I could not come, Lordship. I was around the vicinity.
So second half you.
No, I was around the vicinity, but I could not come when the matter was taken up. So that's why, Lordship. In the morning I was here only, but in this anyway, the matter is all about increment, Lordship.
Why? What increment? How many?
Increment.
Yes.
Only one increment.
He's on next, Your Lordship, before division bench.
Shall I start, Lordship? Start.
How you start? There's the council's not there.
All right.
You have instructions.
No, Your Lordship.
One increment.
Lordship, it happened like this.
You retired now?
Yes, I retired. So
Then we'll
before
have it after 1
before
week.
retiring, after 1 week.
You'll be here. Oh, you still go to Makurat every day?
No, yeah.
Oh.
31.
Yes. 1 week due to absence of Dr. Muzika.
May please Lordship, this matter was laid
Yes,
out
Mr.
at
Bhattacharya,
Your
you
Lordship.
want
There is
something
an
to
order for instruction in this. Lordship,
as
as
far
per
as
the
the-
last order, this one judgment, there is a notification where Lordship was looking for the last occasion, Lordship. That I have.
What's the matter about?
This is regarding pension for regularization because there is a notification qualifying service from the earlier. This petitioner was working as in the district council. Then after that, district council
yes.
school was taken over. There is a notification where Lordship has clearly reflected in the earlier order. Here, in this case, Your Lordship, qualifying service at the time when 1912, he's already been 8 years. Now in that another judgment, though another petitioner was not even 5 years, but then only 2-3 months was there. So Lordship has considered that case also.
Which case is that?
Your Lordship, it is there in the my petition, Annex 11,
Yes,
Lordship.
Mr.
Annex 11.
What instructions do you have?
My lord, here, my lord, the power is not with the department to regularize, my lord. It can be done only by a cabinet approval, my lord, not otherwise.
Simply stated, Annex 11 para this page 40, my lord. There is a judgment. 40. In the same situated case, relying on this notification, Lordship has considered the case.
Of course, in this petitioner, he has not even qualified in that petition Kraibitson or Sangma, the state of Meghalaya. Your Lordship, the para 3 is very clearly mentioned. Para 3 of the judgment, married, Your Lordship, is there in that. So, in this judgment, Lordship has reflected that notification only. But it was filed by the state government only on the earlier petition. They have filed in the rejoinder. This is the notification which they have filed it, and on the basis of that only, the case was considered. In this particular case, petitioner has already been 8 years more than qualifying. Minimum qualification is 5 years. Here he has sub 8 years already. In 1994, petitioner has already reached 8 years, because he was appointed on 1986, Lordship.
And there was no representation ever made by the petitioner?
No, we have make a lot of representation, Lordship. It is,
None of them are on record.
I have enclosed it, Your Lordship, in the repetition also.
Has this been carried through? What happened to this 2012 letter?
On this letter, I do not have a copy, my lord.
I don't have a copy. In the earlier order was paused. Where's MS Brasaji? She appeared in this earlier matter before.
In the earlier matter,
total ignorance on behalf of the department. You don't know what the left hand is doing to the right hand. What happened to this order? Is it considered?
Yes, considered, Lordship. They have considered. Now this Kraibitson already, he already got the money, everything. After this one, they have regularized after this order. It's been processed. He already got all the benefits, Lordship. So this is the same situated case. Of course, this Kraibitson, he has not even reached 5 years or so. 2-3 months was gap. Actually, Lordship has on the humanitarian ground considered only 1 month or 2 months was left to be qualified for 5 years. Now here in this particular case, petitioner had already been 8 years. Minimum criteria qualify.
Where have they refused here? Where have they refused here?
Refused, Your Lordship.
there is no representation on record, my lord.
There's no representation record.
No, he did not make a single representation, my lord.
You'll dispose it of. You let this representation be placed before, then you dispose it of.
Lordship, they may delay, Your Lordship.
We'll give you 2 months' time. This application has been filed. This the writ petitioner by way of the instant petition. Has prayed for post facto regularization of his services. In view of his services rendered as LD assistant.
Yes, LD assistant.
Which school?
It's not in the school, my lord.
No, you're not teaching staff.
Yes, not teaching staff, but in the office. Yes.
Where is that?
That appointment order, Your Lordship, that is in the page 1, type copy is in the office. Administer primary education.
Yes.
Autonomous District Council Tura.
LD assistant in the office of the administrator primary
Lordship,
education.
may I just want to not to
HGDC
disturb. I'm
to
sorry, but then there's a representation actually by the division by
It's
the
never on record, my lord. How can
by
we ascertain?
petitioner only. True, director. May I just have a look?
Is it annexed to
It was never enclosed with the writ petition, my lord.
Because I did not
Neither in
enclose
the
it.
rejoinder.
Yes, the office of the administrator, primary education, corresponds to national law. Stop. Mr. P.T. Sangma, Nepal, learned counsel for the petitioner, has submitted that with the taking over of district council lower primary schools by an act of 1993, stop the government, the state respondents This is the list. Your name is there.
Yes, Lordship.
Page 31.
Page 31. Yes, in this page 31 segment. Yes, my lord. It is number 5. It is Rishubel Para. Page 31, Rishubel Para. That column Rishubel Para. 1, 2, 3, 4, 5. My name is there, Lordship. Sengman Sangma UDA. It is written.
Wait. Huh? Yeah. Mr. P. Sangma submits that in view of the petitioner being a member of the non-teaching staff who have completed 5 years of qualifying service, is therefore entitled to pension and other term and benefits. Submits that as the petitioner served for 8 years.
Yes, 8 years at that time.
Before,
yes. Before, yes.
Year of 1994. Is entitled to terminal and other pension benefits which has been granted in respect of non-teaching staff who have completed at least 5 years of qualifying service. In this connection, the council has taken this court to a letter dated 29 May 2018, wherein a list of non-teaching staff who have completed at least 5 years of qualifying service has been given. Stop. The name of the petitioner, he submits figures in the list at serial number 5. From Resubal Parak, yes. It is further submitted that in similar cases,
that is this one,
namely RPC number 223 of 2023, this court has given the same consideration to other similarly situated employees. Therefore, praise that by operation of the policy of the government with regard to non-teaching staff, the petitioner be granted pensionary benefits. Yes. Next paragraph, Mr. K.P. Parasaji, Learned Counsel, Learned GA, has submitted that the writ petitioner, though having a what kind of case? The petitioner has never approached the state respondents with the prayer made before this court, and the PS has approached this court directly. So he submits that this matter may be directed to be examined by state respondents at the department level, and if the petitioner is entitled, it is but natural that he shall be granted the benefits, service benefits as entitled.
Only that aspect, the regularization, only the cabinet can approve.
No, because that's not.
It follows if the policy decision. See, there is an act. 94.
Yes, that is.
What happened after 2012? That's one, and the other subsequent orders they've been asked to submit. You've not seen the file to submit the requirements. The next, this is 4 December. 3rd August, 4 December 2012 also. See the next year 6.
Yes.
This was submitted since 4 December. I'm not referring to it also.
Yes.
See. Yes, having heard the counsel for the petitioner for the parties and examining the records, it is seen that I'm not saying it is noted that the non-teaching staff of district council, lower primary schools, or attached to the administrator have since been considered in the state government policy in their proposal for taking over the service by the government. Stop. It is seen that in a communication dated 4th December 2012, the Director, School Education Literacy, bracket next year 6 to the petition.
It was addressed to the director.
Has already forwarded the details with regard to the service rendered by the writ petitioner. But it appears, when did he retire?
Yes, he retired, my lord. Yes, he retired on. He retired on 30 November 2023. 2023.
Well, it was
Annex 36.
It was forwarded by the diet to the director.
Doesn't matter.
Yes, Annex Annex 10.
Well, it appears that he was not regularized at all. You sure?
No, not regularized. The release order was 36, page 36, my lord.
See, release order?
Yes, it means that retired when they have mentioned page 36. Page 36, Annex 10. This is the release order.
No, it's just release order. It's not. No, he was not regularized at
No,
all.
no.
This is
not regularized.
12 is regard to service.
Yes.
Not regularized.
Not regularized.
No? Not director.
It is direct, my lord.
It is not director has forwarded. The director, the how long has forwarded?
Is the principal diet, my lord.
4 December 2012. The directors, not from the director's question, has already been informed. Has already been informed about the certain petitioner, including his initial date of appointment, the date of joining service, and the financial implications that came with the post. By another communication dated 29/5/2018, the Special Officer to Government Meghalaya, Executive Department, had again sent details of non-teaching staff, bracket both office and inspecting, who have completed these 5 years of qualifying service. As submitted, the name of the writ petitioner also is present in the set list. This is kind of a deal. 29 May. Another communication is also present, dated 2nd August 2018, addressed to the Joint Director, School Education and C. Meghalaya, Shillong. On the same subject matter, with the details of the petitioner also provided, stamped. The petitioner, has since superannuated on 30/11/2023 with the fate of his services rendered and pensionary benefits which are due still hanging in limbo, LMBO. Stop. Next paragraph. From the materials placed in petition itself, it is undisputed that the writ petitioner had joined since 1986 and had rendered a service for 8 years before the taking over of primary school education by the state government. However, what is strange is, in spite of the communications from 2012-2018, no positive orders have yet been forthcoming. In his view of the matter, though Mr. Kiba Raji had GA has raised objections on representation, the same apparently is not necessary in view of the communications that have already been placed or already in the knowledge of the concerned respondents. So accordingly, the respondents are directed to process the case of petitioner and pass effective orders within 4 weeks
No, my lord. Because, my lord, in our affidavit also, my lord, we have taken that stand that cabinet approval will be required, my lord.
They can take special cabinet thing within 2 months of the date of this order.
My lord, may I pray for 3 months? My lord?
2 months.
Yes. Matter stands
My lord,
disposed of.
only that fact, my lord, that cabinet approval.
Since 12, they've still been writing, they should have processed that time. Now, 12 to now, how many years? 13 years.
Yes, Lordship. Deeply responsible. Most blessed, Lordship.
GW.
Yes.
Lordship, regarding the
Yes.
Lordship, regarding the coach thing, I did not get anything as writing, Lordship, but as per the notification and as per the rules, it is already there that a coach.
He's not a coach in that event.
A coach cannot participate.
That's what we court wanted to know. Suppose you're not a coach in any event. You're not going as a coach. You can't a person go for qualifying. That's the only thing we wanted to know.
Lordship, we were waiting for the something from the writing from the boxing associations, but
No, it's very simple. You don't know how to write a question. So the court's pointed question. Write down. Yes. By order dated in the order dated 5/5/2025, this court has sought specific instructions from the learned counsel for respondents 3 and 4 as to whether, if an athlete is not a coach for a particular event, right, he will be debarred from putting himself for selections in other events,
particular event.
in any particular tournament or events. Stop. Today, MSB University submits that she has not received specific instructions. So this is after 1 week. This is after 1 week. You get it if, suppose you're a coach.
Gotcha.
We understand the question very well. So you're coaching, you're coaching some weight category. Suppose can't you put up as suppose some tournaments coming up, you can't put up for selection.
Lordship, provided he faces the trial, Lordship.
Then let him try. Then
Yes,
we'll
Lord.
dispose it off.
Lordship.
Without written instruction, they say later on they say no, the coach can't take part if he coaches in any other weight category. What will happen?
Lordship, then I'll take instruction.
You understand what the coach is trying to say?
Yes, Lordship.
See, we can't deprive. Suppose the athlete wants to take part. Suppose he wants to take part in the other events, other tournaments, which have to go through the federation. You understand? He has to go to federation, and if you say no, you're a coach in some event, or you're a coach in for some weight category, you can't take part
But
anymore.
he is a certified coach for that.
No, certified coach is fine, but then the thing is that whether he's a coach, whether he can take part or not, that's all we want to know.
Lordship.
The school looks to your existence. We can't say that, okay, you take part, you disrupt everything.
Lordship.
You get it?
Lordship.
See, if a certified coach, whether he can put selection in any tournament. Suppose he's not coaching, nothing to do with that tournament as a coach.
Lordship. Lordship, I'll get instruction by next week, Lordship.
Yes.